Judgment in the matter of an NHS Trust and others versus Y by his litigation friend, the official solicitor, and another.
Lady Black will explain the decision of the court.
Reporting restrictions apply to this case. The court orders in particular that there shall be no publication of the name of the person involved, Mr. Y, or the name and address of any member of his family, the hospital in which he was treated, or the identity of the treating medical staff, or of any information likely to lead to the identification of Mr. Y or his family. Further details of the restrictions are to be found in the order itself. This case began when Mr. Y, an active man in his 50s, suffered a sudden and unexplained cardiac arrest. As a result, he sustained extensive brain damage and never regained consciousness. In this state, he was unable to take in food and water himself and was provided with clinically assisted nutrition and hydration by a tube passing directly into his stomach. His condition was carefully evaluated over some time, and in due course, the doctors reached the conclusion that there was no prospect of any significant improvement in his condition. Mr. Y's family believed that he would not wish to be kept alive in these circumstances, and it agreed with his clinical team that it would be in his best interests for clinically assisted nutrition and hydration to be withdrawn, which would ultimately result in his death. The question arose as to whether it was necessary for the approval of the court to be given before this course could be taken. The relevant NHS Trust took the matter to court, and the High Court determined that it was not mandatory to seek the court's approval when, as here, the clinical team and the patient's family were all agreed that it was not in his best interests to continue to receive treatment. The official solicitor, acting on behalf of Mr. Y in the proceedings, appealed to this court against that ruling. Mr. Y continued to receive treatment pending the hearing of the appeal in this court, but unfortunately developed an unrelated complication and died. The appeal continued, however, because it remained important for the legal issue to be resolved so that the position was clear in relation to other patients in future. The appeal relates to a particular category of patients, that is, those with a prolonged disorder of consciousness. These patients cannot give their own consent to medical treatment. Back in 1993, the House of Lords had to consider a case concerning such a patient, Anthony Bland, who suffered injuries in the Hillsborough disaster, which rendered him permanently unconscious. Some years later, his family and his doctors formed the view that his life should no longer be prolonged artificially. So the courts were asked to, and did, declare that the measures which had been keeping him alive, including artificial nutrition and hydration, could lawfully be discontinued. Commenting on how such cases should be handled in future, the law lords did not lay down a rule that a declaration must be sought from the court in every case such as this before discontinuing treatment. However, they did say that as a matter of practice, an application for a declaration should be made before life-sustaining measures were discontinued. That has therefore been the way in which matters have been handled until recently. The official solicitor contends in this appeal that there is, in fact, an obligation in law to apply for the court's approval before withdrawing clinically assisted artificial nutrition and hydration from a patient with a prolonged disorder of consciousness, whether or not there is agreement between the patient's family and his doctors that this course is in his best interests. Today, we decide that such an application is not obligatory, and we dismiss the official solicitor's appeal. We find nothing in the common law, nor in any act of Parliament, that requires an application to be made, and nor is it necessary to impose such a requirement in order to ensure that there is no violation of rights arising under the Human Rights Convention. Our judgment reviews the important developments that have taken place since the decision in the Bland case. These include the accumulation of years of clinical expertise in treating patients with prolonged disorders of consciousness, and the development of very detailed professional guidance for the medical profession in handling such cases. Also of central importance is the Mental Capacity Act 2005. We conclude that these advances serve to safeguard patients in the sort of situation which faced Mr. Y, and also the medical teams involved in their care, and to ensure that there can be public confidence in the way these difficult cases are handled. We point out that in cases where the way forward seems finely balanced, or where there are differences of view, for instance between doctors, or between doctors and the patient's family, an application can be made so that the court can determine what course will be in the patient's best interests. Indeed, there should be no reticence in applying to the court whenever the particular circumstances make it desirable to do so. And this too is an important safeguard and reassurance for all concerned.